Good morning and welcome to the Fair Housing Law Project's 9th Annual Fair Housing Conference with GBLA. We're going to give about 3 more minutes for attendees to continue to log in, and we'll get started about 3 minutes after the hour. All right, so it is currently 3 minutes past the hour. Welcome to GBLA's 9th Annual Fair Housing Conference. We're very excited to have you here today on for session 1, Fair Housing 101. My name is Cassie Mullick, and I'm the Marketing and Communications Coordinator for GBLA. I will be assisting our 2 guest speakers today with presenting some information to you about fair housing and then queuing in questions that might come in. A few housekeeping rules. You have automatically been muted as an attendee. If you have a question, please either use the raise hand question or go ahead and type those questions in the chat box. We will make every attempt to answer those questions at the end of this session. Inside the handout section, you will actually find 2 handouts. The first is a program for today's session with some background information about our guest speakers. And then there's also a handout of the slides that will be presented to you today. So I do encourage you to download those if possible and have those on hand. Without further ado, I'll go ahead and introduce our speakers and we'll go ahead and get started. So today we have with us Bashar Agabiali, and he is the managing attorney for the Fair Housing Law Project here at GBLA. Bashar has been a managing attorney for the Fair Housing Law Project since 2017. In this role, he manages the project that provides education and outreach on fair housing to the community. He assists with investigations of complaints of housing discrimination and provides fair housing legal services. Bashar joined GBLA in 2008 as an attorney working under the Guardianship Project. After 2 years, he began assisting clients in obtaining protection from abuse by obtaining restraining orders while working in the Domestic Violence Reduction Project. Our next speaker is Gina Kim, who is a GBLA staff attorney. Gina joined GBLA Fair Housing Law Project as a staff attorney in 2013. In this role, she advocates for clients who've experienced discrimination in their housing. Gina represents clients in fair housing complaints filed with HUD and the Department of Fair Employment and Housing, and she also has represented clients in fair housing lawsuits filed in federal courts. Gina provides counsel and advice to low-income tenants regarding fair housing issues. I will go ahead and pass that over to you guys now and begin sharing the presentation.
Great. Thank you so much, Cassie, and good morning to everyone. Thank you for joining us this morning for our first session of our virtual conference for 2022. Before I forget, I believe this session is being recorded, so please keep that in mind. And we wanted to make that, bring that to your attention. This morning, we're actually going to start with a couple poll questions. Cassie, if you could bring those up. Perfect. So our first poll question is just to get an idea of who is in attendance today. If you could please select which of the following describes who you are. If you're an attorney, you're a housing provider, property owner, or landlord, perhaps you're from an advocacy organization or nonprofit organization, or perhaps you're here as a tenant, or if none of the above, you might be other. You could take a few moments to let us know who you are, and that will just be helpful for Bashar and myself as we're presenting today. And Cassie, I guess I'll leave it up to you how long you want to leave that poll open.
I'll give just a few more seconds. We're currently at 70%.
Awesome. And then Cassie, if you can just announce the results once you close the poll.
Sure will. Just briefly, for those who are just logging on, there's currently a poll open. If you can please take a moment to answer that, I'm going to close in about 30 seconds. Okay, so the poll is currently closed with the attendees currently on. 3% are identified as attorneys, 38% identify as a housing provider, property owner, and or landlord, 49% represent from an advocacy program or other nonprofit, and 9% identify as other. We have 0 tenants currently on the poll.
Okay, that is helpful to know, but I guess we have a pretty varied audience today. Cassie, if you can pull up our next poll question, this is number 2 of 3. And again, this question will help Bashar and me just get an idea of our audience today. If you could please let us know how much experience or knowledge you have regarding fair housing law. And the options we gave you are no experience or knowledge, maybe you're very new to this area, some knowledge, or you're very familiar with fair housing laws. If you could please take a moment to answer that poll question, that would be great.
I'll close the poll in about 15 seconds.
Thank you, Cassie.
Okay, so with that, we have 15% who have marked no experience or knowledge, 70% have marked some knowledge, and 14% have marked very familiar with fair housing laws.
Great, that is also helpful for us to know. And then our final question, we're just curious. So this is our 9th annual conference regarding fair housing. And we just want to get an idea of those of you in attendance today, if this is your first time, if you've attended our conference in the past, maybe 2 to 4 times, maybe 5 to 7 times, or maybe you are just a faithful attendee and you have come to almost all of them, 8+. If you can take a moment to just let us know, that would be wonderful.
I'll leave the poll open for about 20 more seconds. Okay, so I closed the poll. We have 50% that have stated this is their first time attending the Fair Housing Conference. 33% have attended the conference anywhere from 2 to 4 times. 10% have attended the conference 5 to 7 times, and 7% have attended the conference 8+ times.
Wow, that's a pretty broad range of experience with our conference as well. But also helpful to know, I think I might be in that last category, but of 8+, but I'm not 100% sure there. Okay, well, let's get into it. I don't think I even introduced myself. I am Gina Kim, and I'm a staff attorney with our department. Bashar and I are going to give an overview of fair housing laws and talk a little bit about our department today. But I am given the opportunity to start us off. So, Cassie, if you could advance the slide for me, please. Perfect. So yes, today our goals are to provide an overview of state and federal fair housing laws. As you can imagine, this is a pretty far-reaching area of law, so we are only going to scratch the surface today in the 1 hour that we have. We are going to talk a little bit about our department and things that we do, because many of you are on the ground working with clients, and you may have clients and just people in your personal life who may experience housing discrimination of some kind. And we would love for you to have us in mind when that happens, so that you might be able to refer that person to our office for assistance. Next slide, please. Thank you. So we wanted to start with, what is fair housing? When we use the phrase fair housing today, we are specifically referring to the idea of housing discrimination. In general, that may not be obvious when we're just in conversation or whatnot, but in a legal context and for the purposes of today's presentation, we are specifically talking about housing discrimination. And the idea that one should be able to choose the housing that they want free from discrimination. And as it's stated on that slide there, fair housing laws protect people from discrimination in housing based on their membership in a protected class. And we'll talk about those protected classes in just a moment. I did also want to make a brief note about the history or the context. So the Federal Fair Housing Act was passed in April 1968, And this was shortly after the assassination of Dr. Martin Luther King Jr. There had been several unsuccessful attempts to pass federal legislation prior to that, but I think a lot of people consider the assassination of Dr. MLK as the catalyst that led to the passage of the Federal Fair Housing Act just 1 week after the assassination. Next slide, please. All right, so this slide lists the protected categories that are covered by both federal and California fair housing laws. So the Federal Fair Housing Act covers discrimination based on 7 protected categories. Those would be race, color, national origin, religion, sex, familial status, and disability. Race, I think, is pretty straightforward. I did want to put a little note there that California recently expanded its race discrimination protections to also include discrimination based on hair texture and style. So it's a little bit probably confusing that that's a state protection that's on the federal protection slide, but I did just note it there. Color is actually referring to the darkness or lightness of one's skin tone, because that has, been the basis of discrimination in housing. That can be the basis of discrimination. National origin referring to the country that one's ancestors are from. Religion, again, pretty straightforward. So those 4 categories were included in the Fair Housing Act in 1968. And then sex discrimination or gender discrimination was added in 1974. I just wanted to note that sex discrimination covers sexual harassment as well as sexual orientation. Sexual orientation discrimination was added as being covered under sex discrimination under the Biden administration, and so that's a fairly recent change. And then familial status and disability discrimination were added to protections in 1988. Familial status discrimination, if you're not familiar with that, is referring to having a minor in the household. And this could be a biological child, it could be a child you've adopted, it could be a child that you're fostering, or a foster child. But yeah, those protections were added in 1988, and disability includes both physical and mental health disabilities. Again, the larger picture idea is that under federal and California laws, it's illegal to discriminate in housing because of your membership in one of these protected categories. Next slide, please. Okay, I may have jumped the gun a little bit, but in California, the Department of Fair Employment and Housing is the state agency that's kind of handles and oversees housing discrimination complaints. But California fair housing laws, the main one being the Fair Employment and Housing Act, or FEHA. California protects against discrimination based on all of those 7 categories on the previous slide, as well as provides additional protections, some of which are listed here on this slide. So for example, in California, it's also illegal to discriminate in housing based on age, specifically if one is 40 years of age or older. Another example is marital status, discriminating maybe between unmarried couples versus married couples might be a form of marital status discrimination that's illegal under California laws. Sexual orientation discrimination is also protected under California law, as well as gender identity or gender expression. Gender expression meaning how one expresses their gender identity through their clothing or maybe their hairstyle, etc. Source of income discrimination is also illegal under California law, and that does include discriminating against someone because they have a housing voucher of some kind. Housing vouchers were added to that protection a few years ago. And the idea with the larger idea, I think, with source of income discrimination is that if one has legal, verifiable, and regular income, that should be considered sufficient for evaluating if someone meets income requirements for housing. So we'll have, I think a lot of this will be clear when we go through some examples, but one example, for example, with source of income discrimination is sometimes we'll see housing providers that are only interested in looking at applicants who can provide their pay stubs to verify their income. So this may rule out or sort of block out housing opportunities for individuals who may have other sources of income, such as disability benefits or welfare benefits, or maybe child support as some examples. Military or veteran status was also added to housing discrimination protections a few years ago. It's a pretty recent addition. And then citizenship, primary language, and immigration status, those are protected in terms of discrimination based on those categories is also illegal under the California Unruh Civil Rights Act, which is also under the jurisdiction of the Department of Fair Employment and Housing. But the Unruh Civil Rights Act prohibits discrimination in businesses, and so the provision of housing is considered a business that's covered by that act. That last bullet point there on the slide regarding arbitrary physical characteristics, this is not actually listed in the state law, but it has been found to be a basis, a basis for illegal discrimination through case law and cases that have been litigated in the courts. And so the idea is that one should not be discriminated against based on physical characteristics or other physical things about you that may have no bearing on your ability to pay your rent or otherwise be a good tenant who complies with the lease. And so I think probably the best example that I usually give of that one is, you know, if someone lost out on a housing opportunity, or maybe is having their housing terminated, perhaps because, you know, the landlord finds out that, you know, you have a bunch of tattoos all over your body, and they just don't like that. If you could show that that's the reason for, you know, the housing denial or maybe losing your housing as an existing tenant, then that might be an example of arbitrary physical characteristic discrimination. Next slide, please. Okay, so this slide is just giving us a little bit more of a closer look at the definitions of disability under federal as well as under California law. I will note that I think pretty consistently for the past handful of years, at least in our office, disability discrimination is generally the most common form of discrimination that we see clients for. And I think that also tracks with trends that HUD and DFEH, government agencies, see in terms of like which types of discrimination are most common for people to file complaints about. And I think that may be because it's common for individuals to have issues with their housing providers about reasonable accommodations and reasonable modifications, which we will also talk about in this presentation. But coming back to this slide, so the federal definition of disability is saying that one has a medical condition. Again, it could be physical, mental, or emotional health. you have a medical condition that substantially limits your ability to do a major life activity. And so some examples of life activities are working, walking, eating, talking, learning, caring for oneself. We also wanted to note that it could be that maybe you don't have that medical condition now, but you previously had it. So you have a history of having such a medical condition, or even that you might be regarded as having such a condition, meaning that you don't actually have that medical condition, but for some reason other people think that you do. Those are ways that, you know, you might meet the federal definition of being disabled, as you might be thinking about disability discrimination. And then we just want to note that California law, the definition of being disabled or disability is a little bit broader. Instead of saying that you have a medical condition that substantially limits, in California, it just has to be a condition that limits a major life activity. Okay. And I think this is where I hand it off to Bashar to continue with the presentation.
Thank you, Gina. Good morning, everyone. My name is Bashar Al-Gabeli, and I'm also an attorney here at the Greater Bakersfield Legal Assistance in the Fair Housing Unit. So we've introduced so far kind of what fair housing is, housing discrimination, and so next we'll talk about kind of in what context these laws apply to. Excuse me. So the short answer is that fair housing or housing discrimination applies to all aspects of the housing industry. By far, what we see here at GBLA is our cases dealing with rentals. So in the rental market between landlords and tenants, and then sometimes in the sale of homes. But if you look at the list in our slide, it applies in every aspect of it. So it applies when someone is trying to buy a home, and so real estate agents and anybody connected to the real estate industry that's dealing with potential buyers and sellers. Fair housing laws apply, as well as rentals. It also applies in the eviction context. So if there's an eviction case where the reason for the eviction, or one of the reasons for the eviction, is based on discrimination or violation of fair housing laws, then fair housing laws apply in that context as well. It also applies during one's tenancy as a renter. It applies in the mortgage market. So there have been cases against fair housing discrimination cases against major banks based on maybe the way that they advertise certain types of loans or offer certain types of terms for members of a certain particular class than others. So like one example would be offering different or worse mortgage rates to African Americans, as an example. It also applies in the insurance market. So insurance companies are liable for fair housing, are responsible to not discriminate against insurers. So for instance, I think a good example would be if a renter's insurance goes up once they become disabled. That's kind of an example that is out there. It also applies to cities and counties in their zoning laws and ordinances, and to make sure that those laws and ordinances, one, do not facially discriminate against people, members in a protected class, but also those laws don't have an undue or disparate impact on people or members of protected class. Typically, we see that either with race or with disability. Next slide, please. And so, what exactly is prohibited? What types of conduct is illegal by fair housing laws? The easiest one would be denial of housing opportunities. So obviously, members of the housing industry can't deny housing opportunities in a discriminatory manner based on someone's membership in a protected class. That also includes not just straight denying someone, a rental or the sale of a home, but also giving them different information that's false compared to other people in the same particular category. So a lot of this will be made clearer later when we go through some examples, but that's kind of the main one. That one, you don't see too often. Most often you see that we see is differential treatment for people who already are in housing. And so people who are already in housing, meaning they're already renting from a place, and the rules, they're getting different treatment from their housing provider versus other members of the same protected class. That's also prohibited. Steering is a kind of an old term. You don't see too much of this anymore, but what that means is that the potential renter or the home buyer, they get to choose kind of where they want to apply for rental or apply for or make an offer on a home, and what area of the town, what area of the complex. Housing providers can't steer them to certain parts of the city, certain parts of the complex based on their membership of a protected class. So maybe the one context you might see that now would be when there's maybe a large complex and the person, the agent is trying to be helpful and steer people with families to certain parts of the complex, or maybe steering them to only ground level units as opposed to second story units. That is not allowed. The person who's applying gets to decide kind of based on what's available, obviously, but what's where they want to go, and can't be restricted to certain parts of it or certain floors. Also, discrimination for associating for members of the protected class. So it's not just the person. Maybe the person is not a member of protected class, but they're associating with someone who is, and that's also prohibited. Advertising. So housing providers can't be discriminatory in their advertising. You don't see too much of this that often. Sometimes you do, not outright, but sometimes there'll be certain ads might discourage members of a protected class. So, for instance, maybe there's an ad that says, well, for instance, like an ad says, must include, all applications must include 3 months of pay stubs. And so that, as Gino referenced with the source of income discrimination, that might discourage people who don't have pay stubs, who possibly are have disability income, maybe they get SSI, maybe they get other forms of non-work related income from applying based on that advertising that says only pay stubs. And then there's also retaliation for asserting your fair housing rights. And so maybe you didn't, maybe the housing provider didn't commit a fair housing violation, but because that person asserted their rights in some way, either by filing a complaint or by doing other things, and then they were retaliated against in some way, that also is prohibited. Next slide, please. So this, what we're doing is kind of, it's a broad overview of fair housing. And so any one of these things really can be its own presentation, and there can be a lot to talk about, especially when it comes to disability. As Gina has mentioned, disability discrimination is one of the major, one of the most the category where we see the most complaints, as well as kind of state and federal agencies see the most complaints on. And then reasonable accommodations is also one of the subcategories where we see the most complaints. So disability is one of the categories where, as a housing providers are required to do something different for the benefit of people with disabilities. And so housing providers are required to allow accept reasonable accommodations and then allow reasonable modifications we'll get to in the next slide. So reasonable accommodation is basically, it's a request by a tenant to make an exception to the housing provider's either rules, standard practice, something that that the housing provider requires, and the person with disability is asking for an exception to that based on the disability. And so reasonable accommodations can be anything, really, meaning it's not restricted to certain types of requests, as long as that the reasonable accommodation is necessary and reasonable. And so an accommodation is necessary if it has some kind of nexus or connection between the disability and what they're requesting. And so if there's a connection between those two, then the reasonable accommodation is considered to be necessary. And also that the accommodation enhances the tenant's quality of life by lessening the effects of the disability. And so that's why I say it really could be anything. We'll go through several examples of kind of what we've seen in terms of common reasonable accommodations. And it also has to be reasonable. And so housing providers, should grant reasonable accommodations, but do not have to provide the accommodation if the accommodation will either result in an undue financial and administrative burden on the housing provider or change the nature of the provider's business. So if it's too costly to provide the accommodation, if there's some cost, that's not an exception. But if it's too costly, that might be a reason to deny an accommodation. Or if it's what the request is so outside of what the housing provider provides, then they don't have to accept it. These kind of, like I said, these requests, they're pretty broad. We can do a whole presentation just based on just on this topic alone. But some things that I want to just highlight and mention. These requests are considered on a case-by-case basis. This is the kind of, like I said, we'll go through some common reasonable accommodation requests. We make them quite a bit on behalf of people with disabilities, and the most common one I think we would see would be, for instance, assistance animals, which I think we'll discuss for a little bit. But like I said, that's could be a presentation all on its own. Next slide, please. So reasonable modifications are requests to make changes to the physical structure of inside or outside the unit, or to the common areas. So these are the kind of things you would think about when you talk about, like, someone wants to install a ramp or wants to install a grab bar or something where there's a change physically change to the unit. And so people with disabilities are allowed to request those, and landlords are required to allow necessary reasonable modifications. Like I said, if it's related to the person's disability and it's reasonable. I think a common kind of misconception among tenants is that usually for modifications, changes to the structure, tenants have to pay for these modifications. and not the landlord. There is one exception, is if the housing provider receives federal government funding. So say it's like, a project-based Section 8 building, or they receive some other types of federal funding, then the housing provider is required to pay for those modifications. And then kind of with the same exceptions as we talked about under reasonable accommodations. So if it's too costly, then they're on a case-by-case basis, that would have to be evaluated. The other thing I want to mention here is for reasonable modifications, although the tenant has to pay, usually for those modifications, there is funding that someone can apply for through the city of Bakersfield and through the county of Kern for homeowners or renters to make modifications. So, keep an eye on that. That might be helpful for some folks to pursue. Next slide, please. Okay, so I think so we have several examples. I think we'll go through that help understand all of this. Individuals of the same race as the landlord are provided more leeway under the rules than individuals of different races. So I think you can tell that's kind of an example of race discrimination for in-place tenants. So although it's not treating someone negatively, but treating people differently based on membership of a particular class. So the idea here is to, as a housing provider or as a landlord, to treat people the same. If you have rules that they're enforced to everybody, and not just giving certain people leeway, that always causes problems. Even if the intent is not because they're members of a certain race, but people will notice oftentimes different treatment, and then they'll assign kind of reasons for that. So as a housing provider, we always tell people just to treat everybody the same. And if you're going to enforce certain rules, to enforce them or not enforce certain rules, is just enforce them or not enforce them for everybody. Next example is tenant who receives income from any really disability related source, so Social Security disability insurance or SSI, it's charged a late fee because Social Security sends the check on the 5th and the rent is due on the 3rd. So this is an example of a reasonable accommodation for a person with a disability. And so the accommodation would be not to charge a late fee, to accept the rent on a certain date after the 5th. We've made those accommodation requests, a few times, and so it is related to the disability because the income is based on the disability, it will have just a negligible effect on the landlord for that. So that's a common reasonable accommodation request. Last example on this slide is landlord has overly restrictive occupancy limits and will not rent the 3-bedroom home to a couple of 5 children. So this example is related to familial status discrimination, and so might be discrimination based on family size. We can talk more about this, but occupancy standard, not the law in California, but just a common standard would be 2 bedrooms, 2 people per bedroom plus 1. And so typically, sometimes landlords will say, well, and so if you're more restricted than that, that's going to be problematic. Like for the 3 bedrooms for 5, 6, so 7 people in this family, and so that would be too restrictive. And then even for maybe if it had 6 children for a 3-bedroom, you have to take it on a case-by-case basis and can have a rigid rule to say certain amount of people, no matter what age the family, no matter how many children there are, no matter the size of the units. You can't just deny it based on that fact alone. Okay, next slide.
Okay, so I think this is back to me for continuing with going through some examples. Thanks, Bashar, for examples you went through. So the next one is a couple decides to become foster parents. When the foster kids move in, the landlord threatens to evict the couple for operating a foster care business without permission. I just interpret this example as a barrier to this couple being able to have the children, the children in their home. Excuse me. Sorry about that. So that may be apologize. That may be a form of familial status discrimination as well. I'm going to skip the next one. We've kind of already discussed that source of income scenario. Landlord approves a couple's rental application, but changes his or her mind after discovering the couple is interracial. That might be another form of race discrimination. Rental advertisement says no kids. I personally haven't seen that, but I think that was pretty common before familial status discrimination was added as a protected category in the 70s. And then like similarly, there used to be ads that said, or I mean, there used to be more ads, I should say, that would say like no Section 8 in the ad, and that was prior to housing vouchers being added to source of income protections, as it was added, I think like about 2 years ago. So yeah, you know, those are some examples of discrimination in advertisements. Next slide, please. Trying to go a little bit fast because I know we're coming up on the end of our time, end of our hour here, and I do want to leave a few minutes in case that we have any questions. So the next two examples on this slide are regarding sexual harassment. So the first one, landlord offers to not file an eviction lawsuit against a tenant if tenant will date landlord. This probably would fall under sexual harassment in terms of quid pro quo. For sexual harassment in housing, there are two main legal theories. One is quid pro quo and the other one is hostile environment sexual harassment. So with quid pro quo, a housing provider, this might be defined as a housing provider making submission to their sexual demands or requirement for providing the housing or providing the housing services, basically conditioning, you know, submitting to their sexual demand as in order to get your housing or something that you would normally get as part of your housing. So yeah, if the landlord here is conditioning, you know, wiping out, you know, not going forward with an eviction lawsuit based on going out with the landlord or going on a date with the landlord, that seems like that might be quid pro quo sexual harassment. And just as a side note, that could be not just the housing provider, it could be any agent of the owner. So it could be the property manager, it could be the maintenance worker, it could be someone who works at the property management office, etc. And we'll touch on that on another slide in a moment. The next example, landlord continuously makes makes unwanted comments of a sexual nature to tenant. This might be an example of hostile environment sexual harassment, which is where you have unwelcome conduct by a housing provider because of one's sex or gender that is severe and that is pervasive, meaning happening frequently, so that interferes with your ability to obtain, maintain, or use and enjoy housing services. So that's kind of the legal definition. But I think the idea here or with this example is that, you know, those unwanted sexual comments may really interfere with your ability to enjoy your housing, and this might be therefore an example of hostile environment sexual harassment. Next example, tenant uses a wheelchair and asks for permission to install a ramp. Landlord refuses, saying the ramp would make the unit look different from other units. This is a simple example of maybe an improper denial of a reasonable modification request. The larger idea with improper denials or improper handling of either reasonable accommodation or reasonable modification requests is that it constitutes a form of disability discrimination. So for this example about the ramp, this is very, it's kind of like trying to keep it simple, but if the request for the modification was not handled properly, that might be form of disability discrimination. The next example, landlord refuses to waive no pets policy for a person with disability related emotional support animal. So we think of these requests for being able to have, for a disabled person to, maybe be able to live with, have their assistance animal, which is sort of the umbrella term that I think HUD uses and that I also use to cover both service animals, meaning animals that are trained to do tasks to help individuals with disabilities. And then the other group of animals is like emotional support animals, which may not necessarily be trained to do any particular task, but their mere existence provides companionship or emotional support to someone with disabilities, often with mental health disabilities. So I kind of lost the train of my sentence there. So this request where someone wants to be able to have, a disabled person wants to be able to have their animal live with them, we often present it as a reasonable accommodation request. It might be, hey, housing provider, please make an exception to your no pets policy, which is what you normally enforce. And instead of not allowing this pet, please let me have my animal. Yeah, so it's usually presented as a request for an exception to either a specific rule or maybe the practice of the housing provider. If that request is not handled properly, maybe there's no dialogue whatsoever about trying to resolve that issue, then that might be a failure to accommodate, which again might constitute a form of disability discrimination. Excuse me. Apartment complex has 2 swimming pools and reserves 1 for adults only. This is an example. We had a case like with this issue at our office a handful of years ago, and the idea is that pool time that's for adults only sort of blocks out or can't think of, like, it does not provide equal opportunity for families with children, and so that might be a form of familial status discrimination. Next slide, please. Okay, so I did want to mention that in housing discrimination laws, there is this idea of vicarious liability, meaning that liability for housing discrimination goes up the chain. And so the property owner is always at the top of the liability chain. And so a property owner can be held liable for the unlawful acts of any subordinate, such as, the property management company that they hire to handle day-to-day operations or oversight of the property, or maybe the on-site manager, a contractor that does pest control or something. Yes, again, the property owner is always potentially liable for housing discrimination violations of any subordinates that are under the owner. And so this is sort of why we think it's best practice for all you housing providers out there to have regular fair housing training, especially if you have new staff. And so I'll make a shameless plug that our office does provide those types of training. And then we do want to provide education to housing providers because our ultimate goal is to try to prevent and also address housing discrimination. I did also want to make a note that, as a housing provider, like let's say you're a property manager or maybe a real estate agent, you may find yourself, if you ever find yourself in a situation where your supervisor, whether it's, your supervisor at the property management office or maybe, your client, like the property owner, if you're a real estate agent, is asking you to engage in some kind of discriminatory action, like, hey, make sure we don't rent any of these apartments to, I don't know, people who are Latino, or don't show this property to anyone who's in like an interracial relationship or something. If someone is asking you to engage in discriminatory behavior as a housing provider and you refuse to do so, and let's say you get terminated from your position because you refuse to engage in discrimination, you may also have a fair housing claim that you could pursue. And so I just want to throw that out there, because although our office, we generally are representing and working with tenants and not housing providers, there are situations, I mean, that's an example where fair housing protections may apply to a housing provider. Next slide, please. And then very quickly, our theme this year, we obviously are still in the pandemic, or I mean, technically, I think we might be in an endemic in California, but just a few thoughts about fair housing and COVID-19. I think the items on this slide might have been more common towards earlier in the pandemic, where we just want to point out that a housing provider cannot ask a tenant to move out or otherwise treat that person differently because they have a disability, including COVID-19. If they want, if a housing provider wants to try to evict someone because they suspect that that person has COVID, that would be that might be a form of disability discrimination. And I guess the next bullet point there, it may not even be that tenant has COVID. They might just be perceived to have COVID. So, if you can tell that your this particular neighbor is like, this tenant is like having trouble breathing, or exhibiting some kind of symptom of COVID, and you like want to push the issue and try to evict the tenant for that reason, that might be a form of disability discrimination. Next slide, please. Some types of reasonable accommodation requests that we have seen during the pandemic. Sometimes if someone is immunocompromised, let's say, they may want to ask to postpone an inspection of the unit because they don't want to have people coming in to the unit just for purposes of social distancing. And so that might be a request for an accommodation that they ask for. Someone might ask for more time to move because they have, again, concerns about social distancing. I don't know that I've seen this personally as much, but I have had trainings where, during the pandemic, there's been people have had a lot more mental health like issues and struggles with anxiety, for example. And so I guess like at a training I attended, like the need for emotional support animals in particular during the pandemic has been increased. And then very quickly, I just want to mention this point where that came up, I think, at a collaborative meeting that I jumped in on, that, without going into all the details of why we're in a very tight rental market locally, I think someone made an observation that their clients, many of whom have ESAs or emotional support animals, have had difficulty finding housing. And, this is just a thought that we have is, if a housing provider does not want to provide housing to people in certain protected category, whether it's, disabled persons who have animals that help them with their disability, or fill in the blank category, in theory, it seems like it's not going to be that hard for them to come up with a reason not to rent to people in that group, because there's going to be a multitude or numerous individuals who are applying who are qualified, and they can just, if they're going to have a way to not rent to persons in a particular protected category, just by the fact that there are so many people applying for each unit. Okay, we're at 10:59 for sure.
Yes, just in the last few remaining moments, just wanted to mention that we talked about cases we've seen at our project. Just wanted to say that at GBLA, we're the Fair Housing Law Project, we're funded by HUD and the City of Bakersfield to provide fair housing services. We cover most of the county, everything, actually almost all of Kern County, except for some areas in North Kern. Next few slides, Cassie, please. And then, and what we do here, next one, and then like the last one. We've alluded to this, but what we do here is we provide legal, we do kind of three areas. We provide education and outreach to the community, to tenants, to landlords about fair housing. We investigate complaints of housing discrimination. And then we also provide fair housing services by requesting, reasonable accommodations or filing complaints or those types of things. And then how to contact us is in the last slide. You can call us with that number or email or visit our website for more information about what we've covered, about all aspects of fair housing that we've covered here. And that's the end of our presentation.
Thank you guys so much for that. So we do actually have some questions. Let me go ahead and get to those. So to start, we did have Grace Palma. I saw that you had your hand up. I'm going to go ahead and unmute you at this time if you'd like to go ahead and ask your question. So I have given permission for you to unmute yourself. I'll give you a few moments. Okay, so we'll go ahead and move into the next question. So the first one we have is, it's from a parent. It says, who is responsible to fix something that we broke, like tiles on floor or shower heads? Is that covered for fair housing?
Bashar, do you want to take a stab?
Yeah, I would say that that's not really, so like, fair housing, like we said, it's discrimination. And so that wouldn't necessarily be covered under fair housing laws. It would be covered under landlord-tenant, law, and so would be governed by your rental agreement. So I think people should just kind of look at the rental agreement, see what it says about damages. Typically, if it's tenant caused, then most of the time it'll say that the tenant is responsible for that cost, but just check your rental agreement.
Okay, and our next question is it legal to move other people in when the house was only rented to 2 adults and other adults move in?
Okay, the question is it legal to add additional tenants into a rental home? Is that basically the question? I mean, that I think we would probably, I'm sure there's probably more facts going on behind that situation. On the one hand, it seems like it might involve the rental agreement that your rental agreement that you had with your landlord about what the contract was for. Are you renting one room in the house? I'm not sure. And then the landlord decides that they're gonna move in additional tenants, or were you contracted to rent the entire home? But this is not necessarily, those issues are more, again, landlord tenant law. I mean, the first thought that crossed my mind is this might involve an occupancy standard issue, potentially, whether helpful, like helpful for the tenant or not. I mean, in terms of that principle that Bashar had talked about, where in California it's not like the law, but there's this guidance, I would say, that having 2 persons per room plus one more person is generally considered okay. But then of course you have to take into consideration the size of the rooms. So for that question, I apologize. I think I might need more information about the facts of the situation. But yeah, Bashar, I don't know if you have anything else to add.
And you can always forward that question to me at the email address provided through the confirmation emails, and we can definitely send that out to have that further addressed further. So another question that came in was, how much can a rent be raised if rent has not been raised for 5 years?
Oh, Bashar is better at these questions than me. Go for it, Bashar.
So that's a difficult question, because we would need more facts in terms of the type of housing it is. So again, this would be landlord-tenant law, which we also do at GBLA, deal with the issues relating to landlord-tenant. And so the amount of rent that can be raised, like I said, is dependent on how long the person has lived, the tenant has lived there, whether the housing is subject to the Tenant Protection Act, which is a law in California that provides, certain grounds for, terminations, protections, and there's a cap on rental increases if it's subject to that law based on your housing, and then what type of notice can be given. So I can't give a definitive answer based on just that information.
Okay, we have another question, and then we have a hand raised. So the last question in the chat box is it legal for landlords to ask if an applicant has sued a landlord in the past?
That is a good question. I actually had a client come across that question in looking for housing. I am having trouble thinking of why it would be like a form of discrimination to include that question like off the bat. Obviously, that question seems like the landlord wants to know, like, to me, it strikes me as like, hey, I want to know if this person has previously sued their landlord, because, are they going to similarly sue me if I, do something this person doesn't like? And I feel like it's a little bit unfair of a question, because sure, there's going to be some people who are kind of litigation happy. They like to sue, and some of those things may be not as legally meritorious or legally valid as other issues. But sometimes people sue because they experienced a significant wrong at the hands of their housing provider, and it's perfectly legitimate and valid for them to pursue their rights. So I feel like it's an unfair question, but my short answer is I think it's an unfair question, but I don't know that it's illegal to ask that.
Yeah, I have Julie Smith with her hands up. I have unmuted you, Julie, if you'd like to ask your question. Okay, so looks like those are all the questions we have in the box. If you have any other further questions for either of our presenters today, feel free to email that to me at kmulligan@gbla.org. You will receive a confirmation email with a short survey. If you can take a moment to complete that survey, it would help us with future sessions. And then we hope to see you all next week. So next week at 10 a.m. on April 13th, we're going to have session 2 titled More Than Words. We have 3 guest speakers: Heather Kimmel from the Housing Authority of the County of Kern. We have Jason Cater with the City of Bakersfield Planning Department, and Urania Esparza from Kern County Planning Department. Each of them will have a short presentation to go over different things that the community is doing to help with housing and to ultimately create opportunity to prevent fair housing discrimination. So again, thank you so much for joining us, and we'll go ahead and end this session, and we look forward to seeing you next week.